Hello everyone, welcome to CCA live webinar. Uh, Myself Harmeet Saini, a CCA Register Migration Agent. In today's live webinar, I'm going to discuss about the public interest criteria PIC 4020. So what are the consequences of this criteria and how it is triggered, and how can we seek the recovery option under this request, and what are the waivers available or any other, if the still visa refusal occurred, is there any ART review is available after PIC 4020 natural justice order. So let me upload some slides for you, and then we will begin with the webinar. So the main agenda of this webinar is what trigger public interest criteria 4020, and what are the consequences of this criteria, and is there any recovery option available in terms of waiver, can we seek waiver for this criteria, and what are the ART appeal available under this criteria. So let's discuss one by one. This is a very important tool used from the Department of Home Affairs. Uh, so let's introduce first what is PIC 4020. So it is called Public Interest Criteria 4020. So PIC 4020 is a powerful legislative tool used by the Department of Home Affairs to minimize the frauds, to ensure the genuine information is used and genuine documentation is used while lodging the visa application. And Mr. Minister must be satisfied that all the information and identity documents provided are genuine and accurate. Uh, to apply this public interest criteria is applied to most of the visa applications, either they are temporary visa application or permanent visa applications. For example, for student, skilled visa application, partner, family or work visa application. So everywhere this criteria is applicable and have to be satisfied. So the main pillar of this public interest criteria is there are three main pillars. One is bogus documents, another is false information, and identity fraud. Bogus documents, let's discuss one by one. Let's take bogus document first. What is bogus document? This is the first pillar that trigger PIC 4020. The bogus document is defined as the document that the minister suspect has been fraudulent or altered, uh, or obtained with the false information. So all these documents are considered under the category of bogus. Uh, for example, fake work experience references. If you got to apply for any work visa under any stream, especially for the employer sponsored streams, and counterfeit English language test results, or if somebody alter bank statements or financial documents, or false birth certificate or marriage certificates when used in terms of any subsequent partner visa applications. So all these documents are taken to very seriously if somebody provide bogus documents. The second pillar is false information. This is again quite very serious. So sometime the applicant failure to disclose some important information, for example forgetting to mention your previous visa refusal, not even from Australia or even from any country, if it is not mentioned in your visa application. Secondly, the character history. So every visa application asks for character history, and you have to tick that section that you don't have any case pending or any previous criminal conviction. So if you provide false information for that sort of information, and department later find out that you hide that information, and it triggers PIC 4020 straight away. Similarly, employment information, some people do uh, work references letter or references from the employer to meet the point based criteria, to match the uh, information, to match the nominated occupation. So this is again a not a lawful process. Family status, sometime you failure to disclose the family members in the visa applications, that especially the immediate family members or dependents in the visa application. So all this information, if department come to know late in the later stage when you apply some other application, or if you applied previous application and hided that information, even the PIC 4020 can trigger in your next visa application as well, because of the information supplied on the previous application. So all this information have to be correct with the department record. And third one is quite very serious, is the identity fraud. uh, if the minister suspect that identity is the person is not having the right identity, the consequences are quite serious, and then definitely there is no waiver for identity theft. For example, mismatch biometrics, fingerprints, or photographs, uh, and personal detail on the visa application form, and the most important is questionable passport authenticity. So if passport is altered, or somebody using the fake passport or somebody else passport to apply, so if minister suspects that there is a identity fraud in the visa application, then it is taken as quite serious, and there would be 10 year of ban on such applicants under PIC 4020. So main consequences of PIC 4020 is minimum of 3 year of ban for next visa application, or 10 year bans. So for example, if you are having false information or supply any bogus documents with your application, and department find out, and in that case they may put on you as a 3 year of exclusion ban. Similarly, if there is a identity verification failure, then they may put 10 year of exclusion ban as well to grant for the next visa application. Uh, this is quite serious. And now discuss what is the strategy. Is there any waiver available for PIC 4020? So department not refuse the visa application straight away. Before the visa application refusal, under public interest criteria 4020, the department will usually send an invitation to comment under the section 57 national justice order. So they send you an email letter uh, regarding to explain the situation, or explain the uh, if you provided any false or bogus document or false information. uh, and this situation is very critical. Yeah, you have to, because the information was provided, and this is, and they ask for the information what they find suspected, why this information was, or why these sort of documents are provided. So the situation is quite critical at that time, so definitely you have to seek a special migration advice, and reply to that section 57 request with the detailed explanation and the evidences as well. If you supply only detailed explanation, that is not enough. Uh, so to win the PIC 4020, definitely you have to show some compelling grounds, compelling and compassionate reasons why these allegation, or why the natural justice order not applied to you. So especially you have to take care of whenever you're replying to that national justice order. So you have to take care of if there are any Australian citizen children, it is in their best interest, or is there any hardship to Australian partner or spouse, or is there any special care need for any Australian resident or Australian citizen. So mean to say, so all compelling reasons, if they are affecting that PIC 4020 to any Australian citizen or Australian permanent resident visa holders, so you can explain those situation in in the response to that PIC 4020. Uh, Similarly, if it is an employer sponsored visa, in that case you can include that economic impact for that particular business in which you are employed for, and if there are any business that can be uh, affected and implies Australian citizen and permanent resident with that decision. Similarly, if you are holding very highly specialized skill where there is an acute shortage in Australia, so that things can also be mentioned when replying to that natural justice order. So usually what we do, the simply explanation letter is never enough. What we do, we build a comprehensive legal file including the evidences, for example statutory declaration from the witness, expert psychological assessment for family impact, and detailed financial and employment records, and proof of genuine intent and any act of error. So everything we include and prepare a file according to the Australian migration law and policies, and then we submit those evidences with the explanation letter to reply to that national justice order under PIC 4020, which is quite very critical. So still, if the visa got refused after your normal explanation, still there is the option for the ART review if the application is lodged onshore, or even some of the temporary application which are lodged from offshore as well, in terms of employer sponsored visa category. So employer may lodge ARTs, similarly family members can do. So yes, there are ART appeal options are available, but I would like to say that nowadays there are quite changes in the ART process. So because now it is a faster timeline, so decisions are prioritized to clear the previous backlog. And another things, the ART is updating the review without the hearing. Now ART, some temporary visa applications, the visa cases may be decided without the oral hearing, and fresh assessment. The ART provides a de novo review system looking at the case from the scratch. So all these new updates the ART is following at the moment and trying to speed up the ART process. But yes, it's a good news. So ART appeals is available if your visa got refused. Uh, so this is all about the PIC 4020 and their importance, how it is triggered, how we can seek waiver of this criteria, and how to show the documentations and submission to reply for PIC 4020. Still, if you are curious about your case and not sure how to move forward, and you need a question regarding the fee and the process for your visa applications, please do contact our CCA nearest office. Our offices are located all major cities of Australia. You can send your request on our email address info@cca.com.au, or you can directly contact me on 0451 369 851. So we are here to answer your queries as soon as possible. And thank you so much, and thanks for your time. And any information you're seeking, please do contact us. Thanks for today. Thank you.